So Nicole's gonna monitor questions, thankfully, and it's being recorded to the cloud, so that's good. So thanks for the few joining us in person today, and those of you that are on Zoom. Going over the new purchase or the new listing agreement is what we're gonna do first. But before I get to that, I actually want to make an announcement. So I never like to have egg on my face, but I have egg dripping off my face at the moment simply because the MLS last over 2 weeks ago, I have an email that says that it was brought to our attention that one of the agents had said, hey, broker agent friendly. And meaning that they're willing to cooperate with another broker agent, pay a compensation. And unfortunately, like I thought that was wrong at that time. And so I asked the MLS, I have an email back from Patty at the MLS that says, no, actually, it's kind of walking that line, but it's okay. So I come in and I tell everybody it's okay. Last Friday, we had a broker manager forum for the MLS, which was well attended. And there was a gentleman there. He's actually the CEO of Next Home. And he provided a lot of good information about upcoming lawsuits that we're probably going to see in our industry and how things are going to kind of keep propelling. So we're going to be making some changes as well. But anyway, that scared the MLS enough for them to say, nope, you can't say that anymore. So 2 of our agents got audited yesterday and it's been removed. So I just tell you, I realized that, it wasn't allowed, it was allowed, now it's not allowed. So unfortunately, you're gonna get audited. No longer can you put in there buyer agent friendly or buyer broker friendly, any of those terms, anything that leads to compensation whatsoever. So, all right. So then we'll get started with the exclusive right to sell agreement. I pulled up the large size purchase agreement just to make it easier for everybody to see. And those of you that are on Zoom, I hope that they can see. I don't know that they
The
can see that.
camera's kind of glary.
Yeah, that's the only bad thing. And it doesn't have the numbers on it. I wonder if there's a way, can you make me a co-host by chance that
Yes.
I could share my screen?
Are you signed in?
Yeah, I mean, we could try and dim the light up
I'm
front.
just thinking it's the glare off of Rich's head.
Probably is.
He got me. I think it.
Are you signed into the Zoom?
I can sign back in. Yeah.
That might help, Rich, the one that you had off, I don't know.
I mean, I'm happy to do that.
I can see the flamingos.
Yeah,
Do you think that helps, Nicole?
can you tell if the lights help make a difference?
Cause,
It doesn't.
Okay.
okay. It's just me in
Um,
person.
I don't want to say switch because then I take it over. So if I join, see what happens.
There you are. And you are co-host now.
Okay. I'm gonna keep myself muted so that they can still hear me on Zoom there. And mute myself here, okay. Let's go ahead and share my screen. There, I'm getting there.
Hmm.
How do you think that helps, actually?
Where's my share button? Okay, they should be able to see that.
Perfect.
Now people should be able to see.
Yes.
Stay host. Okay, thanks for your patience, everybody. We're 5 minutes in, but that's where we're at. So now people can see. All right, so I got the large version of the exclusive right to sell agreement. A few changes have been made to it over the time. Like I said, I'm gonna make a little bit further changes as we continue to navigate this wonderful world of real estate with all the changes. But basically, the first paragraph just talks about the address of the property that you're listing for sale, and then also the price. So you would just fill in whatever the address is and then the price, and then the term would be whatever your listing date is. So that would go in here. So whatever your listing date is, you want to make sure that it's within 2 days of you entering it into the MLS, because you have to have it in the MLS within 24 to 48 hours, depending upon if you're doing any public marketing. The clear cooperation agreement is still there. We still have to follow it for as long as it's there. Hopefully it stays, but it may go away. We'll see. But basically the main thing is you have 48 hours, not including federal holidays and weekends, to get a listing in the MLS. So if you were to put, let's just say in here, let's say you had 1010 in here. Morning. let's say you had 10-10 in here and then all of a sudden you put it in the MLS today, you're gonna be found in violation because it wasn't within that 48 hours. So just make sure it's within that 48 hours. All right.
So then again, we don't have to hit it on the exact date? So if I,
Well, if I put today, if I put today's date in 10-15, I have to have it in the MLS within 48 hours. I have to have it in the MLS within 24 hours if I put a sign in the yard or do any public marketing.
right, I just didn't know that, I thought that the date of your contract had to be the date it goes in the MLS. I thought that the date on here, commencing on, that's the date had to go in the MLS, but not necessarily.
Yeah, not necessarily. It really
Okay,
depends.
Because you
I
have a
mean,
window,
you do have a window. You have a 48-hour window, yes. So if I wanted to say, my list date would still be today. When I enter it in the MLS, I'd still have to put today, so it would show it was on the market 2 days,
okay.
even though it wasn't in the MLS.
I
So
see.
you have to go by the date that you put on here, but you do have 48 hours to put it in.
Okay,
So
but you can't put it in early, right?
you cannot put it, well, you can put it in incoming early,
Right.
but you can't, yeah.
Make it active.
but you can't make it active. And then the term, typically we do 6-month listing agreements, you can do a 3-month listing agreement. I don't really recommend going less than 3 months. If you do a 2-month, you know, you're probably gonna have to extend it unless it happens to go under contract right away. And then you can do a 2-month, but a 1-month would be really foolish because the chances of you getting under contract and closed in that time without having to extend it would be foolish. But as we see the market times, I would say 3 months as a minimum would be the shortest term. So we're gonna talk about this dark or this, I guess it would be bolded paragraph. This paragraph is what Ohio House Bill 466 put in place that says that all documents that the public are dealing with when it comes to compensation must have on it. So whether it's our listing agreement, it's in our buyer broker compensation agreement, it's also in the representation agreement. It's anywhere that a consumer is gonna be signing for a fee that they have to understand that it's 100% negotiable. All right, and then for section 1, I've tried to make this a little bit easier to understand. I know it gets a little bit difficult, but you will get it. And so basically, section 1 only deals with your side of the compensation. Just the listing side has nothing to do with a buyer's broker. Now, it could have to do with you bringing the buyer, but it has nothing to do with another agent. It is only you, your team, you individually, whatever. So section A is your normal listing agreement. That just says that in consideration, you're going to charge $295 and blank. Now, that blank could be blank. You might not be charging anything in this section. I might have zeros there or dashes or whatever, because we already have the $295. But let's say it's a team agent and they want to charge an additional $100 because it's a $295. That's why it says and, we could put 100 in there, and 3%. Now, again, this is not applicable for everybody. If you don't charge more than $295, you don't fill that part out. So it already says there's 3,500 here is our minimum compensation. However, we know that we don't really enforce that. That's really just there for you to use as necessary, you know, with the clients. So what I would say is, worst case scenario, if you said, well, Rich, I'm gonna charge $2,500, I'm gonna leave the $295, I'm gonna put $2,500 in this box here. The percentage is gonna be 0, and I'm gonna cross out the 3,500. So you have the ability to negotiate the compensation with the consumer, and they have the ability to negotiate with you in section A.
Did the 3,500 used to be there even when we were more likely doing the 6%, like?
Yeah, the
covering both
3,500's
sides?
always been in there.
Okay, so
Yep.
it might have been that we used to split that amount, but now it's that section, it would really be just on the listing.
Yes, so
Okay.
typically we did split the 3,500 because we would give away whatever, you know, you were giving away. But yes, now it's just for the listing side, 3,500.
Okay.
Yeah, and again, that's negotiable. You can change that. We just put it in there for your benefit. All right, and then B, so this is how I envision, I haven't had the opportunity to actually talk to a seller yet about this. But I would say this is how I envision a conversation going. All right, Mr. and Mrs. Seller, I will represent you. These are all the things in my listing presentation that I'll be doing on your behalf. I will be negotiating on your behalf when it comes to inspections, repairs, price, all of those things that I would typically do. However, a buyer now has the right to come to us, as they always have, but they're exercising it more now, the right to not be represented by a real estate professional at all. And typically, when they are represented by a real estate professional, that buyer's agent would let them into the property and show it. They would also write the offer. They would also negotiate repairs, provide comps, and do all those things. They would be here and figure out when the inspections are going to be, sit here the whole time, whether the appraisal's coming, dealing with the lender, all those things, dealing with title. All those things I don't have to do typically when I represent you, because that's a representation by a buyer's agent. But buyers now are coming to us and saying, I don't want representation. Well, in those instances, I then have to be the one to step in and write the offer. I have to negotiate the repairs. I have to talk to the lender. I'm turning the deal into the title company, following up on earnest money, all the things I would do if I were working with a buyer. And so for that reason, I am gonna charge 4% if you'll allow me to work with an unrepresented buyer. Do you allow an unrepresented buyer to come into your home? The answer is yes or no. And you might have to explain what an unrepresented buyer is in a little bit more detail if they have confusion, but I think we all understand what an unrepresented buyer is in this situation. So that's where I might say that I'm gonna charge 4%. Now, a seller might say to me, hey, I expect you to do all those things for 3%. I'm not paying you 4%. And by the way, I don't want you to bring an unrepresented buyer to my home. I want them to be represented. They could say any one of those things. That's a conversation with your seller, and that's totally okay. So again, these are not always applicable.
So I
Scott,
have a question on that. So let's say it's somebody who does not want representation. And our seller does not want to have somebody who is not represented. But they want an offer and stuff. Do we have any legal obligation to share that, hey, this is what they're telling me they want to offer, even though they're not willing to accept an offer from
so I would tell you that you have to present.
24 hours, right, to present. But if nobody's written it, but they're telling me verbally what they want.
Well, there's no time frame on when you have to present an offer. You just have to present all offers.
Okay.
You have to present all offers in a timely fashion. That's
Okay.
a timely manner. Yeah, there's nothing that says 24 hours. But what I would say is if a seller says to you, I don't want an unrepresented buyer, then they should probably put that in writing and you should keep that in the file to say, I'm not able to show the home to anybody that calls me off the sign or the internet or whatever and says, I wanna see that home. They can either come through during an open house or they have to come through with another realtor. And it could be me, but that goes to the dual agent section, so we have to have that conversation next. So, Mr. and Mrs. Seller, do you authorize unauthorized or unrepresented buyers to come through your home, yes or no? It's really that simple. Because that's the other thing too, is you get a sign call and of course you wanna represent the seller, you're gonna go show the property, but then you're the one that's working with them to get them pre-approved and answering all their questions. So to me, that deserves more compensation. Whether you get that from the buyer or you get it from the seller, doesn't matter, but when they're being unrepresented, you're still going to be the answers that they need. Yeah, it's still all the work.
And you told me you could not ask an unrepresented buyer for the commission.
Right, you can't charge an unrepresented party for compensation. I mean, that's the same thing as, we can't charge a buyer that we don't represent the $295 additional commission. There's just no way to do it. If we don't have a legal representation agreement in place, whether it's listing or buying, there's no charge. Nicole, is there a question? I feel like.
Yeah, Susan, can we have the yes or no on the form?
Can we have the yes or no on the form? Oh, that the seller would allow or not allow. I mean, I'm sure that's something that we can add. Yeah, I mean, we're not gonna be able to please everybody, and I will tell you, the more boxes that we put on these things, the more confusing it gets, and also.
Things get missed.
It's more things that do get missed, but also just more explanation to the seller and more checkboxes and more going over things. So I'm not saying we won't do it, I'm open to that. But like I said, we will be updating, I'm sure, this listing agreement in the next few months again, just based on all the things. All right, so that's section B if it's an unrepresented buyer, and then section C, the conversation is gonna say, Mr. and Mrs. Seller, I am representing you in the transaction, though oftentimes a buyer may call me to see the property. Would you allow me to enter into a dual agent situation where I have to be basically a neutral third party? I wouldn't be able to tell the buyer what comps, I wouldn't be able to provide them comps or even provide them with what to write. And I couldn't give you confidential information that they share with me and vice versa. I kind of have to be a neutral party. Are you okay with that? And if they said, sure, I'm okay with that, well then let's see. Based on that situation, I'd like to charge 5% compensation in section C because I'm gonna be a dual agent. And the seller might say, well, wait a minute, I'm not paying you to be a dual agent. I don't have a problem if you wanna be a dual agent, but if you want compensation, you get it from the buyer. Well, then in that case, I might have to put 3% in there because the sellers just told me, I'm willing to let you work as a dual agent, but I'm not gonna pay you to be a dual agent. Or they might say to you, no, in fact, I don't want you to be a dual agent at all. And so in that case, then we're gonna put 0 because the seller is telling me I cannot represent a buyer on their home. So these three, A, B, and C, are really just conversations with your seller. It's just you understanding what they are allowing you to do and not allowing you to do as you represent them. Only covered the listing side. That covered you if you are just listing in A. It covers you if you are just listing and an unrepresented buyer comes in B. And it covers you if you are just listing in C and you represent the buyer. That only to do with you, your team, that's it. So it's number 2 that we go into where the seller says they are going to offer compensation, and what is that compensation gonna be? Totally separate from number 1. So I've had agents tell me that they filled out, let's say, for example, 6% on A, B, and C, and then put 3% on line 2. Well, technically, you just got 9% from your seller. So understand those are 2 totally different sections, 1 and 2, totally different. Okay, all right, so number 2, you will see if you're using a different version of this, please get rid of it, but it says the seller agrees to pay blank of the full purchase price, transfer or exchange directly to buyer broker through escrow. The reason that that's on there now is because even though up above it says that splitting fees or compensation between brokers is allowed by Ohio law, we are being told that most large brokerages are getting away from us collecting the buyer's compensation and then giving it to the buyer's broker. We're taking us out of it 100%. We are saying if the seller wants to offer something, great, you're paying them directly. It's still going through escrow, nothing will change. The title company is still taking care of it, but that's really the biggest thing, is just the verbiage on there. I will tell you, after the managers meeting that we had, the broker manager meeting from the MLS and the gentleman from Next Home, the CEO coming, we have some hard decisions to make because there are some new lawsuits that the attorneys that already sued during the Sitzer Burnett case, they're already looking for new things to sue over. One of them is with a listing company sharing compensation with a buyer's broker. So that's why we've changed it to paying seller directly. It's not because we want to be a pain in your rump and keep changing things. It's because we're trying to keep us all out of hot water. However, his comment is to say, you shouldn't even be having that on there because there are steering cases that are already coming up, because there are agents that are, there are sellers that are saying, oh, well, you told me to offer 2.5%, but really the buyer's broker came in and only asked for 1%. So you just made me give away 1.5% of my my equity in my home. You really weren't representing me to the best of your ability because you just gave away my money. So we're looking into, and I honestly do believe we're only a few months away before buyer broker compensation won't even be on anybody's listing agreements going forward. I hate to say that, I know you don't like that answer, a lot of you, but you have to get on board with the new way that things are going, and it's really buyer's agents get their compensation negotiated with the buyer, sellers get their compensation negotiated with the listing agent. Period, no more blurred lines. We're not sharing anything anymore. That's just the way it's going. And we don't want to be one of those brokerages that gets sued either, right? I mean, that would affect us drastically. So anyway, so I say that to you to say buyer broker compensation can or cannot be. You can leave number 2 0 if you're looking to negotiate that compensation. If the seller says, hey, I'm willing to pay it, but I'm not offering anything. When they bring me an offer, I'll look at any compensation. Great, then the seller is not offering compensation to the buyer's broker. Holly, do you have a question?
I have stopped calling and checking to see what people are asking, and I haven't had many agents call and check with me. When I make my offer, I just put what I want in there, and I've gotten it every single time.
Yeah, Holly brings up a great point, and I think, and we've been saying this for a while now. There's really no reason for you to call and ask the listing agent what compensation they're offering, because we pretty much know most of the large brokerages, the answer is 0. They're not offering it anyway. They didn't procure it on their listing agreement. And like I said, I think that's where the whole industry is going to be going in the near future. But more importantly too, to Holly's point, it doesn't matter what they're offering. It really has no bearing on what they're willing to pay, because if they say, well, yeah, I'm willing to pay up to 3%, but I called and that's what I got, the buyer's agent might have only been asking for 2.5%.
Yeah, I think it's a change, like she said, at first, I had people wanting me to call
Yeah.
find out what it was ahead of time. And that's less so. In Howard Hanna, you could go on theirs and you could see it on their website, but I think more and more, including that's what we're doing, we're not offering it.
Yep.
We're having the conversation, you're probably gonna be asked, but it's gonna be another negotiation as part of the sale.
Yeah, no, agree.
I found it super important in how you present it and what you write or how you explain the offer, so they don't counter or take it out. Cause they've come back to me and said, we're not offering that much, and I'm like, explain our offer, why it is the way it is, and every single time I've gotten, my commissions have gone up ever since this happened.
Yeah, most buyer's agent compensation has gone up that we've seen. Now, that may not always be the case. If we get into where it's a buyer's market, you might have more buyers, then it might flip, and the buyers might be like, hey, there's hundreds of agents that are willing to work with me. I'm gonna charge you X% or pay you X%. And if you don't like that, too bad. I mean,
Right,
that could be. So we'll see how that plays out. But like I said, number 2 is one of those things where it's in there for now. Utilize it if you want to. You don't have to. You can leave it 0 and then it's negotiable. What you cannot do is put the word negotiable in any of these, and you can't say a range. So don't do that, because that is 100% illegal.
can you put like to be determined?
Nope.
Okay.
No, everything has to be closed-ended. There can be no open-ended compensation, whether it's on a listing agreement or a buyer representation agreement. The consumer must know the exact amount that they're gonna pay, whether it's a % or a dollar amount, based off the sale price. Yeah. All right, and then basically it just says, all compensation is gonna be paid upon the transfer or sale of the exchange of the property, and basically we have the right to say, listen, if we presented you with a full price offer, you really owe us a compensation for it, but the chances honestly between you and I of going after it, if the seller says, I decided not to sell, probably slim to none, and none is probably the answer. Until other brokerages start suing over these things, we've always been in an industry that we just know we only get paid when something closes. And if it doesn't close, no matter the reason, we don't sue the buyer or seller typically. All right. Lockbox access, anybody that needs Supras, I know an agent that wants to sell about 20 of them. If anybody's using them, but lockbox access just says that the seller is authorizing you to put a lockbox on the property, and that you can share that information with the buyer's agents, inspectors, appraisers, and other third-party companies that, whether they're doing photography and things like that. But the seller releases the broker, which is important, and its agents from any liability, injury claims, damages arise from related to the showings or access of the property. I will tell you, I've had several agents that their seller has wanted us to cross that out, and they don't want to be responsible for anything going on in their home, whether somebody slips and falls or whatever. Ultimately, they are, whether it's in here or not. We can't control whether a buyer is going to end up suing them if they fall or slip or do anything like that. So I would just say it's important to know that you should never give a lockbox combination out to anybody without your seller's written permission first. So, if I set up the showing and I'm unable to make it, and I call Holly and say, hey, Holly, can you go show this house for me? And I just give her the lockbox code, that is 100% a blatant violation of the ethics. I didn't have the seller's permission. I got permission for the lockbox code, but I didn't get permission to give it to Holly. So you want to make sure that you don't have somebody on your team setting up showings for you or anybody else. If you're the one that set up the showing, you're the one that got the access code, you are the only one using that access code. All right, and then authorization to market just says that, we are gonna market the property, and I think this is important because we've seen where, whether you have a sheriff or a judge or somebody that's, their privacy is important to them, they may say to you, I don't want any interior photos of my house online, I don't want a floor plan of my house online, I don't want any of this stuff online, simply because they just don't want it shared, they're a more private person. But if they don't say that, this is giving us absolute permission. Now, I know in here it does say that another, we can't really control basically that a buyer's agent and or a buyer may take pictures or videos inside your home. But if you are on the buy side, make sure you're getting permission before you just take videos or pictures inside somebody's home, because really you don't have the right to do that. The pictures are online, and if your buyer's like, oh, well, I want to be able to take pictures, my own pictures, ask the listing agent if you can have that permission. If you're doing a video tour, you can set that up in showing time all by yourself. You don't have to get any special authorization as long as you list it as a video tour and they approve it. Electronic surveillance just says it does or does not. You pretty much basically might as well assume that anywhere that's not a bathroom has a video camera or an audio device listening to you. One way or another, you've got some type of surveillance, whether it's the neighbor's Ring doorbell, whether it's that Ring doorbell, somebody has eyes on you, so be careful. There was one agent that, I don't know what happened, but the story goes, she flicked off a Ring camera on purpose, but her license got suspended for 30 days.
Wow.
So I don't know what the altercation was with the homeowner, but that was the gist of it. And then fair housing, this is the same sentence that, or paragraph that's in everybody's listing agreement, purchase agreement throughout the state. It's Ohio Revised Code, fair housing on block busting and steering and things like that. Disclosure, it just says that the seller has read the property disclosure form and filled it out to the best of their ability. You should never be present when the seller is filling that out because they're gonna ask you a question. Well, the basement sometimes gets rain, water in it. How should I fill that out? Well, you don't want to be the one to answer that. So the best thing to do is basically just say, listen, here is this document, the lead-based paint document. I can answer questions if you have questions on not how to fill it out, but what goes where. I can read a sentence or clarify something, but I'm not going to be able to answer you and say, well, you can only put, well, if it only happens on heavy rains, just put, oh, water only happens on heavy rains. You don't want to answer any of those kind of questions. And I will tell you, I think some of the agents thought it was a scam, but Seller Shield has been emailing you all. It is a product that we can use. It's 100% free. It basically what it is I use it myself because how many times do we get a lead-based paint disclosure back or a property disclosure back where the seller hasn't filled something out, right? It's blank. They filled out a good amount of it, but they haven't filled out all of it. So in those instances, that's where the Seller Shield is wonderful because it's a video. It walks them through how to fill out those forms. It offers them, I think it's like $200 to $400. It offers them an insurance policy if they were to get sued outside the transaction after it closes or during the transaction, that this would cover them up to $20,000 in legal fees. And it doesn't mean just from filling out the disclosure if they fill something out wrong. It's any legal things. The video explains that. It goes through and tells them you can skip. The agent can provide it as a closing gift if you want. If you pay for it up front at the time of the listing, it's less expensive than at the end. That can be a nice gift for somebody. It's not an inexpensive gift. Like I said, I still think it's like $200, but you know, it could be worth it if that's your thing to start marketing. But anyway, it then, as soon as they complete that document via Seller Shield, it gets emailed back to you immediately. It's completely filled out and it's very professional looking. So I would say, you know, that's something that you could use. You don't have to. Confidentiality, the listing brokerage must keep things that are confidential. We can't, you know, if I have a husband and wife that's getting a divorce and they say, I don't want people to know that, because it does affect the value of a house. A lot of times people will go in and they'll see only men's clothes or only women's clothes, or they'll see a side of the closet, whether it's man or woman, that doesn't have a lot of clothes or something, and they'll think, oh, something's going on here. I can get a better deal on this house. We haven't seen it in the seller's market that we're in, but it could happen. So that's the kind of information that you kind of want to keep quiet about. Okay. And then any excluded fixtures. Fixtures can be anything from a bathroom mirror that is hung by a nail or a couple screws that, you know, is a family heirloom or whatever the case is, or their favorite mirror, all the way to I'm taking the dining room chandelier because it was my grandmother's. Whatever it is, if it's attached to the property, including curtain rods and blinds, if you're taking those things, you need to exclude it here, and not just here, it needs to be excluded in the purchase agreement as well.
I have a question about lockboxes. I
Oh,
missed.
yep.
I have noticed an increased number of buyer agents giving out lockbox codes to their clients. How do we handle these situations?
So you should never give a lockbox code out to a client. It doesn't matter if it's before, during, or after the sale. I know there's a lot of times where an agent's like, oh, I don't want to drive to Akron. I'm just going to give the lockbox combination to my buyer. You can't do that because the chances are that agent uses that same lockbox combination on every single one of their lockboxes. So if I give you 1, 2, 3, 4, and that buyer enters the home, 9 times out of 10, they're probably not going to go down the street where they see the same listing agent and ransack that house, but the chances it could happen. Kids could do it. I mean, teens could do it. Adults could do it. You just never know. So you should never, ever give a lockbox combination out. And if you really want to do something about it, you can contact their broker or manager. And worst case scenario, you can turn it into the division of real estate. I caution you on doing that because I will tell you, you could pretty much bet that if you get turned into the division of real estate for giving out a lockbox combination, your license will be suspended for 30 days. You will be mandatory continuing education and a fine. You can pretty much guarantee it because they're tired of seeing the same thing. They are really cracking down on it, and they have been for a few years. It might take you a while And unfortunately, when you do get your license suspended or any disciplinary action, it goes in the division's newsletter and everybody can see it. So it's not gonna be a secret that your license was suspended or why.
Can you give it to your seller though? They ask?
Oh, you can give your seller the lockbox combination if you want to. I mean, it's their home. But again, I would also caution you to say, if you don't change that code the next time you put it on another property, you basically just you just gave a blank key
Yeah.
to that seller to another property that you listed for sale. It's really not in the best interest to give your sellers a lockbox combination, but it does happen sometimes. I mean, I've told, first of all, I use Supras. I don't use combination lockboxes, and that's just because if I were a seller and you sat down and explained the difference to me between a combination lockbox and a Supra, I'd say I want the Supra. And I would take the agent that uses the Supra all day, every day, because it emails them when it's open. I know that unless you are a member of the MLS, you don't have access to that lockbox. So I feel much more secure having that on my home. That's just my personal opinion. But you have sellers that'll say, oh, I don't want a lockbox on my home. Here's the garage door code. And then you give the garage door code out to every buyer's agent there is. It's just foolish. So you should school your sellers on the difference between, giving out a lockbox combination, worst case scenario, versus their garage code or their lock on their front door that is just open to anybody.
And I think the person who asked that question is wondering, what do I do about it? Because maybe there are some people, it's a problem. They're handing out codes to people and they shouldn't be. And I think we wanna be good agents, we don't do that. And I think the people who, I don't have a problem turning them in because they're doing the wrong thing.
Yeah, I mean, it's happened. I mean, like I said, a home inspector, what we have seen, and I've gotten a few calls lately about this, is agents are being more lazy and they're like, oh, I'm not gonna go sit there for 2.5 hours for a home inspection. But they don't tell the listing agent that there's no licensee gonna be there. They just give the lockbox combination to the buyer or to the inspector. The inspector doesn't realize that they're doing anything wrong because they were given authorization. They open the lockbox, they're in the house, the buyer's there with them, the family's parading around. And all of a sudden, the agent shows up in the last 10 minutes of the inspection, if at all, and says, oh, great, how did everything go? I'll go ahead and make sure the house is locked up. At least they're doing that, but the fact that they didn't get permission from the seller to have somebody in their house is totally unauthorized access. You can't do that. You should always be, a licensee should be present. When I say a licensee, it's a real estate licensee, not a home inspector licensee, should be present anytime there is public or anybody else in the property. Now, if they're going out to do, an inspection on the outside of the house, as long as you have the seller's permission to say, hey, somebody's gonna be there to look at the roof, that's a different story. You don't necessarily have to be there, but you wanna make sure you have the seller's permission in writing. All right, and then home warranty, just whether you do or do not elect to have a home warranty on the property. It's a great way, I can tell you, I mean, America's preferred home warranty, you can always offer the warranty and you can take it off, worst case scenario, in a negotiation if you don't want to, but it can be a nice service to offer to that buyer, especially if you're trying to get your listing to stand out in some form or fashion. Point of sale inspections, it just says that, the seller is gonna be aware and the seller shall apply for these inspections at the seller's expense. I think that that's one thing that gets missed a lot of times in our listing agreement that people don't realize is if you're listing a property with a septic and well in Stark County, the septic we know must be inspected. So you have the opportunity to have it inspected at the time of the listing and just go ahead and provide that information, or you don't. You can say, no, I'm not gonna provide that information. But the seller could say, well, I don't wanna pay for it. If the buyer wants an inspection, let them pay for it. Well, that's all well and good, but the thing is, you have to have the inspection done before the county's gonna let you transfer the property most of the time. There are exceptions. So I don't know if you guys like that, dislike that, but I will tell you, it's been in our listing agreement, and I guarantee most of you have never read it. It's been in there in the previous listing agreement, in this listing agreement. I even had one agent on a team, they called and they said, I can't believe that the buyer wants the seller to pay for it, and the Summit County law says that the seller will provide it. Well, it doesn't say who's gonna pay for it, but it does say in Summit County that the seller is going to apply for it. So this goes a little bit further. If you don't want the seller to pay for it, cross it out. It can be negotiable, but it's in there. All right, and then the seller obligations basically just maintain the property. We are not inspectors. We aren't coming over to plow the driveway before a snowstorm. I mean, some agents might, but typically we're not going to, we might pop in if they're out of state for a week or something like that, but it's not our responsibility. If the house floods, if the power goes out, if the sump pump backs up, whatever happens, we are not those people. We are not property managers. It's not our responsibility. And then cybersecurity, just that, you know, we're not gonna ask them for their private information. The title company may ask them for their social security numbers or give them wire instructions or anything like that, but we are not going to be asking for that. And then this is a binding agreement, and it just says, again, this is provided for real estate purposes only. They can speak to independent professionals for accounting, you know, because we always get the question, well, am I gonna have to pay capital gains tax? I don't know the answer to that. It depends on, talk to your tax preparer. I always cringe when they are like, well, I'm my tax preparer. Well, you better ask somebody else, because you don't know the answer, you know? So, and then they would sign it and then fill it out. So any questions about just the listing agreement? Yes, Holly.
Back to that, the buyer's compensation, what you're offering, where you have to fill in the blank,
Yep.
so. Can you do zero, like go back, you can put 0, so, and have every intention to pay something, but see what comes in, like, would you do that, or would you put a set number?
So what I'm saying is I would not necessarily put a set number in here. Again, I think you have to change the shift of your mind, right? We've always said, oh, we're fighting for the buyer's agent, you know, they're gonna get compensation, but you now have the ability to negotiate your own compensation as a buyer's representative. You don't have to rely on pulling in the driveway and an agent's offering 1.5%, you're like, oh, this sucks, I've ran these people all over town and now I'm only getting paid 1.5% on $150,000 house or whatever the case would be. So you have the right to negotiate it. So I will tell you, I think that most of our agents honestly are probably taking advantage of putting 0 in number 2 and just allowing it to be 100% negotiable. The reason I say that is because, again, I think if I were a seller, knowing the landscape of how things have changed in real estate, if I were a seller now and you were sitting at my table and you're telling me that you think it's in my best interest to offer a 3% or a 2.5% for the buyer's agent compensation, I'm gonna question why I would do that, because I've already seen offers where the buyer's agent asks for 0 because the buyer is paying them and they want their offer to be more competitive. So I would then question and say, well, Holly, are you really looking out for my best interest? Because why would I pay 3% more of my equity to a buyer's agent that may not be asking for it? So leave it 0 and let it be negotiable. And that's when somebody would call you and say, Holly, are you offering anything? And the answer is the seller is willing to negotiate and look at all offers, put it in your offer. Scott?
That's, I think, what Lynette sort of said for us is that, you know, we sell it as a way of looking out for them, that we put 0, but we also couch it in that, but be prepared that they may ask, but why would we offer this when they may only ask for this?
Right.
And so I think it's another way of proving your value to them, being aware of the market and what it is and how our industry is. And then when they see that, because a lot of them, they're willing to offer something, but why at this stage lock yourself in? So it's a good way to make yourself look better in your presentation.
I still think on your net sheets, in my opinion, whatever you think compensation would be, I would put that on there. So if you think an agent might ask for 3%, I put that on the net sheet and I would just highlight it and, you know, with a note that say, you know, may be applicable or, you know, possibility or something like that. But I would really drive it home to the seller for them to understand you're probably going to get asked for this, but it's not guaranteed, but you should consider it.
And you had pointed out to me when we were on the phone for a lot of days, I appreciate that. As I wrap my head around it, but you know, your point was, well, this is a contract, so if you've secured 3% from your seller. And that buyer comes in and maybe that agent has only secured 2.5 or 2%, well, now you've got a gap, right? You've got 2 contracts in place, what are you gonna do, go back and tell your seller that you overcommitted them to a certain amount of money, and technically you have a contract, so what happens with that extra 1%, right? So why not mentally prepare them to pay maybe 2.5 to 3.5%? And like you said, I've done that on the net sheets, that's exactly what I've done, but I'm putting a 0 there and saying this way, we don't have a gap and whatever. And it's more conversation because I'm reminding my seller that buyer's agent is already gonna have to have a document in place with an X amount of percentage in place. And we don't know what that is, so why commit to something when we don't even know what they have on the other side?
That's right.
So and same thing then with letter C was what I was having a problem with, because I had a couple of my sellers who, when I tried to say, if I represent both sides, this will be, and I'm like, but I just feel like, who am I, so they're like, wait, what? And so I feel like, who am I working for in this? Like, here I am, Mr. Sellers, looking out for you, and I owe you fiduciary. And by the way, if I go ahead and represent both sides, my fee is 7% or 6% or whatever it is, right? So like, without even having to sort of, I don't know, prove myself, I'm just gonna go ahead and make you sign that you're already agreeing to pay my representation of a buyer. When.
But a buyer could come to you and say, hey, Lynette, I want you to represent me, but I'm willing to pay you 3%, and I'm not gonna ask the seller to pay anything.
Yeah,
And in that case, then you have, again, two agreements. So,
yeah.
and that's where I will say at that broker manager meeting, that's where a lot of this is going, is who do you actually represent? So if you really are looking out for the seller and have a fiduciary duty, you know, even in C, the conversation might go like this. Hey, I'm only gonna do it for 3%. All of these are gonna be 3% because I represent you and that's what I'm willing to do. Versus another agent that might say, hey, I'm only gonna charge you 3% on A, I'm gonna charge you 4% on B, and I'm gonna charge you 5% on C, because I'll be a dual agent. Instead of, you know, having the leg up to say, hey, I'm gonna do all three of these the same, I'll negotiate my own fee with that buyer when they come. That,
Which, so then for C, as you and I talked, let's say we want 3% on our listing
Mhm.
side, so then putting 3% under C is essentially like putting 0 for number 2. It's, you're
That's
saying
right.
it's negotiable because we'll talk with that buyer and we can always still ask for my compensation through that buyer agent.
and through that
the
offer.
Buyer, yes, through the
Yes,
offer.
through the offer.
Exactly.
Yeah, and like I said, I think number 2 will eventually. If I had my way, honestly, I'd pull it now. But I'm at the point where we've had enough changes, we've had a lot of changes, I know agents are still offering it. And I don't wanna take that away from those agents that are doing that, but I will say, I would think that by. 3 months from now, it's probably coming out, most likely, and I won't promise that, and it doesn't mean that you still can't say it's negotiable. But we're probably gonna follow that rule.
And one more question.
Yeah.
Where you have to get permission from the seller in writing, say, you know how we used to have a blank that you could write people in, that could. Or maybe it's another form, like if I had somebody. Showing for me while I was.
Oh, yeah,
On vacation or
Mhm.
something, their name needs to be in there, can you do kind of like a blanket, like? Another agent from my office or?
We have that in ours.
so the teams, I have not updated it in .loop yet. There are a few teams that have right to delegation on the listing agreement, which I will be updating in .loop. I haven't done it because of all the changes but it does list on there, you can list up to 3, you can list more than that, but the biggest thing to remember is if you're delegating to another agent in the brokerage, essentially that agent represents the seller. They do, because if you're on vacation, or whether you're not on vacation, you're just out of town for 2 days or whatever, or unavailable, and I say, hey, Holly, work with my sellers here, there's an offer. Well, you now have personal knowledge of what the offer was from another agent. You also might have personal knowledge of what their payoff is because you're doing a net sheet for them. All kinds of private information. So you can no longer now just be like, oh, never mind, I don't represent the seller anymore, and go about your day. You're gonna have to be on the agency disclosure form on that offer, for sure. And there's nothing that says that you can't do that now. You would just wanna get something in writing from the seller that says, does Rich Cosgrove have, permission on behalf of my seller to stand in for Holly? And it's a yes or a no, as long as they understand it, but we will have the delegation. The only thing with the delegation is the delegation on the listing agreement must be done at the time of the actual listing agreement signature. You can't go back and add them later and say, oh, well, I'm going on vacation, let me add this person. No. If the seller's authorizing that up front, that's fine. But otherwise, you're gonna have to do an email, something in writing that says, I have your permission in this situation, I'm leaving town, I need this person to handle.
That's what I was.
Yep.
Thanks.
Yep, that's fine. All right, let's go over the purchase agreement. We're only about 45 minutes in. I want to try and get you guys out of here in the next half hour if possible. And I'm happy to stick around for questions. I definitely don't want to cut anything too short, but let's go over the purchase agreement. So I'll actually say I hate this purchase agreement. I don't like it at all. There are so many things I want to change in here. The attorney that we use is Cindy Lambert. Cindy Lambert is one of the #1 attorneys in the state that works with a division in Northeastern Ohio. So she's highly sought after. She works with all the large brokerages with the exception of Howard Hanna. They have their own legal counsel in-house. And so as we were preparing for all these things, she had seen a lot of purchase agreements. She liked certain things, didn't like certain things, and basically said, let me put this together for you and let's shove it forward. And it wasn't that it was a last minute thing, but it started to get last minute because she was so behind the eight ball to get everything done. This is the product that came out and we said, okay, we're gonna roll with it for now. I realize that there are things in here that you just don't wanna deal with, and that's fine, I get it. We will get it changed. I think that we need to get through the next few months just because there are still changes. If I change this purchase agreement today, it's probably gonna get changed again in the next couple of months, so I hate to keep doing that to you. I've got plenty of notes on all the things that you hate. I have notes on the things I hate. I understand what we're changing. Please provide the feedback. If you see something in another purchase agreement you like, let us know. Tell me what you don't like about this one. All right, so the main things on here are the permanent parcel number on line 1. I think we always miss, not always, many times, agents miss the fact that there are more than one parcel number when they're purchasing a property. I mean, I've sold homes where it has 2 parcels, the house is sitting on both, there is a line straight down the middle. You could not separate those parcels because you'd cut the house in half, right? And so I put both of those parcel numbers in the listing agreement, but on the purchase agreement, it doesn't always populate that way. And so you need to make sure that you understand the permanent parcel numbers that are available that the buyer is buying, because I've even seen it to where one parcel number has been on there, a title company goes all the way through closing, only transfers that one parcel, and that second parcel is still in the other owner's name. So, and thankfully in that instance that I did see, the seller was like, oh yeah, that was supposed to transfer. But man, it could have been a lot worse. The seller could have said, nope, wasn't in the contract for that price. I want $20,000 more for this lot. So it could have been a problem. And then the address on line 2 and whatever county it's in. Purchase price, offer price on line 3, earnest money amount on line 4. The biggest thing is make sure you're turning in the earnest money, and if you're not getting it, the buyer's turning it in directly, make sure you're getting something from the title company that says that they received it. It is your responsibility as the buyer's agent to continually follow up with that buyer to make sure that they've turned it in. And if they haven't turned it in within a timely fashion, in fact, that's one of the things I'd like to amend on this. One of our sister companies has that the earnest money will be turned in within 3 business days. I kind of like that personally because with the way things are online right now, there's no reason why you can't turn in your earnest money in 3 days. And we've seen it where 7, 8, 9, 10 days go by, earnest money still isn't turned in, and we are still moving forward as if everything's okay. Right, so that's kind of a problem, and I've gotten plenty of calls where it's like, well, the buyer hasn't turned in their earnest money, we got another offer, can we take it? The answer is no. But at least if we had a day count in there, the buyer's now in breach of the contract, and you could say, the buyer's in breach of the contract, either perform or this. So we'll look into adding that too, but make sure you're getting that earnest money submitted or collected, whatever side you're on. And then the balance of the down payment due, whatever they're putting down. You know, whatever the balance is that they're putting down, if they're putting 20% down, great, 20% goes in there. I don't have a problem with people putting a percent in there, even though it has a dollar sign, you can put 20%, that's fine, or you can put an amount, you could put $100,000, whatever it is that you wanna put in there, that's fine. And then the amount to be financed, this just gives the seller a really good idea of how strong your buyer is. I have seen agents that will put in there to be determined in a lot of those, amount to be financed, and line 8, balance of down payment due, and I will just tell you, when I'm the listing agent, the agent that filled out this form in its complete entirety, and I have a full picture and my seller has a full picture, I'm gonna advocate for that buyer more than I'm gonna advocate for the to be determined. Because I don't know, maybe they're only putting down 3%, it's a conventional loan, but it's 3%. My seller may not wanna take that one, they might wanna say, I want the 20% down. Or I want the one that's offering earnest money that's $3,000 instead of $500. So those are all very good fields to fill out and represent your buyer to the best of your ability. Number 10, just, is it conventional, is it FHA, VA, USDA, cash, or anything else? I think the biggest change that we did, online as 11 through 14 that I have changed on the purchase agreement, it is not reflected here, is we've gotten rid of this wonderful little box over here, simply because it's a little confusing. It's, the commission will be blank % of the purchase price. So am I putting the purchase price in here again, or am I putting in the amount of compensation? Because it looks like a run-on sentence. There's no period here. And then it says blank to be deducted from the seller's proceeds. So if I put in the purchase price here, you mean you're giving me the entire purchase price and the proceeds? So it's a little confusing. I'm gonna tell you that in my opinion, right now, I would not put the purchase price, I would put in here the compensation that you're seeking. So if it's 3% in this line, and let's say it's $100,000 house, I'm gonna put $3,000 here.
I've been
That's-
putting C line, whatever it is up above,
Sure,
just. Cause if it changes and I put a concrete number there, well, it's one more correction I've gotta
it is.
try to remember when we negotiate that, so I
It
don't,
is.
yeah.
So, and like I said, we got rid of this on the updated purchase agreement, it's one of the changes that I made, we haven't rolled it out yet. I know it's a little confusing, and I've gotten the question on line 12 is the buyer's offer is or is not contingent, why would you have an is not there? Because a seller would automatically then say, oh, well, then I'm not paying it, it's not contingent on the offer. And yes, that's true, but that is there because if I'm working with a buyer that says, Rich, I want you to try and get your compensation negotiated in the sale of this house, but I don't, if they say no, that's okay. Then I'm gonna check the box is not contingent, I'm gonna try and get it taken care of, but I don't want my buyer's offer in a multiple offer situation thrown aside because I said it is contingent. A seller might go, oh, they're cash, I like the terms, they're gonna close fast, so I'm just not willing to pay that compensation, but I want their offer. That's okay, so that's why that's in. But I do oftentimes get that question, so I tell you, that's the reason that it's in there. Secondary offer, we used to have a secondary offer form, I do like this part on our purchase agreement simply because it now basically just says, listen, this is a backup offer or it's not. And most of the time, it's not gonna be a secondary offer, but if it is, you don't have another form, it's already on here, and it says that, that the buyer's receipt will be done on or before whatever that date is that you're gonna put in there, so it just says that it is a secondary offer. Financing, so 21 through 26, it's just gonna call out what kind of financing that the buyer is going to obtain a written loan application within 5 weekdays, excluding, of course, it says federal holidays and loans, or federal holidays and weekends, and then the loan commitment. Loan commitment is not something that we typically look at in our region of the country, but it is huge from my understanding up towards the Cleveland market. Like they look at that, they look at it in Southern Ohio. But what would typically go in here is if you're gonna do a closing within 45 days, I would write 40 days for loan commitment. I only do like 3 to 5 days less than the amount of my closing days because I want that loan commitment. That's basically when the lender says, hey, we have everything we need, it's gone to underwriting, we're committed to this loan, and then we're giving a clear to close, which is our terms, not necessarily the lender's term, and it might not close for another 3 days because it has to go to title. We just need the commitment, that's all we're looking for. There is actually a written document that says loan commitment on it, we don't get that, but you can. And then lines 27 through 38, seller agrees to pay blank towards buyer's expenses. Now, in this particular instance, where we're at in the industry now, you could simply say to somebody, hey, I'm not gonna ask on lines 11 through 14 up here for the seller to pay the compensation. I'm gonna ask for it in the form of a concession, if you're okay with that, Mr. Buyer. You need to pay me $5,000 is what our agreement says. Would you allow me to put that in there and I'll just go ahead and take that as a credit? You'll get it as a credit on your side of the paperwork at the closing table. And the buyer might say, yeah, that's fine. But this is also meant not just for compensation, it's if the buyer really does need help with their down payment, closing costs, prepaid points, any of that stuff. And then line 31, it would just say that the seller would make any repairs not to exceed blank. I typically write in here $500. If the house is really bad and it's a VA or FHA buyer that I have, I might put $1,000 or $1,500 or $2,000. But if you see chipped or peeling paint, if you see that there are no GFCI outlets in the kitchens and bathrooms or wet locations, if you see there are no handrails, there's any broken glass, you might as well figure that the VA or FHA appraiser is gonna call it out. So you might as well build it in there. This has nothing to do with the home inspection. This has everything to do with the appraiser. Okay, and so I typically, that's my rule of thumb is 500 at a minimum. Do not put to be determined in there because to be determined does not get that seller to mandate that they're paying anything. It's to be determined. That means it's 100% negotiable at that point. And if you put 0 in there, that means the seller doesn't have any obligation to pay anything. So be careful with how you're writing these. Funds and documents. So again, this is a section I really don't care for on the new purchase agreement, line 42. Those dates are pretty much always gonna be the same. If I write in here that today's date, or I'm sorry, the closing date's gonna be 10/31/24, then I'm probably gonna put the same date over here because that's the date that the title will be transferred on. Typically, we've seen this in older purchase agreements where it took a couple days for something to record, maybe the recorder's office was backed up. Today, we have everything pretty much done in Stark County, Summit County, they're all electronic. So the chances of it not getting recorded the same day are slim unless they're signing after 4 or 5 o'clock, maybe 3 o'clock in the afternoon, whatever. So typically, those are gonna be the same. But again, worst case, if they're not the same, it doesn't matter because it says title shall be transferred on or about. So even if it's a day later or whatever, it's not the end of the world, okay? All right, and the parties direct, this is another part that I don't like, is this is the only spot where you actually have the title company, that the representation for the escrow is. It would be, in this case, American Title Solutions, and her escrow agent to confirm receipt of the earnest money. Well, that's the only place you can put the title company. So it's a little confusing because it's great that that's where the earnest money is going, but who's doing the title work? Well, it says to the right of it, escrow agent. So we know in the business, that's who our escrow agent title company is gonna be. But I think it's a little bit not as clear as it should be. So electronic data security just says, again, we're never gonna ask for their information. Personal information or financial data, just another disclosure. Possession, and this just says the seller will give possession to the buyer on or before, whether it's 3 PM if I'm filling this section out, 3 PM. And then blank days after closing by the escrow agent as defined above, or blank, whichever is later. So I might say, or 30 days. So it's gonna depend, it's either going to be on or before 3 PM, 30 days after closing. Or I could put a specific date in here, but whichever one is later is actually going to be the time that you get the possession. And what we had her take out was the definition of closing being the deed being recorded. We did have that intentionally taken out because we're about the only brokerage that was following that rule to the letter. Most title companies anymore, you're getting an email that says that in our eyes, it's considered funded, filed, and closed, even though it hasn't been recorded yet. And most buyers are signing a document at closing that say, when you get that email, it's considered closed. So we took that out because we were seeing where there was a delay, and then we were arguing with agents on whether they were getting their keys or not. So walkthrough, don't have a separate addendum, it's lines 59 through 36. You can put in there 3 days before closing. I would tell you, even when a seller is keeping possession of a property after closing, it's still a great idea to do a walkthrough before you close on that house, because there have been times where a basement is backed up and a seller has gone to closing and not said a word about it and then claims it never happened until after title transferred somehow, but the buyer walks in and the basement's flooded. So it's still a really good idea to walk through that property and make sure that at the time of closing, it's the same as what you expected. Then fixtures and equipment, I know that some of the agents don't like it. I will say that we did put in here that there are mineral rights, which is on line 68 in there. They think it's in a weird spot because it says fixtures and equipment, and that really doesn't make sense for the mineral rights to be there. That is where our attorney put it. We can talk to her about putting it someplace different, but I did want to bring to your attention that mineral rights is now written in to our purchase agreement automatically. And then, of course, all the other things that you can keep with a property, whether it's the oven, microwave, fireplace tools, smart thermostats, all that fun stuff. And then if it was not included, it'd be in lines 82 through 83. So that's where anything that was in your listing agreement or anything that the listing agent is saying doesn't convey, that's where you put that.
So if mineral rights are not included, where do we?
You're gonna cross that out.
Okay.
Yep.
And then what if it's unknown? Cause I just saw that where a listing, the seller, according to the listing agent, says seller does not know what's going on with the mineral rights. And that, I think we're on the lower end of that. Whenever I go further south.
Yeah.
In 100 years, that's gonna be a mess down there.
Yeah,
It's a
yeah,
mess
because
now.
everybody owns mineral rights that are,
Nobody knows who.
nobody knows who's got them. The biggest thing is when you're buying a big parcel of land, typically the people want the mineral rights, especially because they're buying it. Whether they think they're gonna get oil and gas royalties, or maybe a well is gonna be put on it or whatever, so I would say most of the time people want those, and it's unless they're excluded, it's included, right? I mean, that's the thing too, is even though our previous purchase agreement didn't say mineral rights specifically, they are included, you get all the rights unless it's excluded. You know, you're getting a general warranty deed, which gives you all of the rights to the land above, below, and on top of. But unfortunately, there were a lot of sellers that had no idea that their mineral rights had been sold years in the past.
Yeah.
Right, so if you don't know, I would definitely make it a contingency of the offer that says, you know, buyer. Once the mineral rights convey, this offer is contingent upon title company verifying that mineral rights convey, or something like
And
that.
I think it's gonna become a bigger issue, because Nick Santucci last week
Mhm.
spoke about that the State House is taking up the issue of mineral rights, because it's gonna probably open up even bigger.
And I
Depending
think
on
title
what's present.
companies do that, they refer you to somebody else.
Well, the title
that's-
company would be able to tell you, based on the title search,
Right.
typically whether or not the mineral rights convey. They may not be able to tell you who owns them, but they could say, they could look at the previous deed to say they were included or they weren't included.
And I think the state is seeing this as gonna be a bigger issue, because oil and gas industry is gonna grow even further probably here. And they have to come up with a solution for us, because
Yeah.
we don't know, and we have people asking.
Yeah, yeah, mineral rights, I mean, it's a huge thing, especially down in Tuscarawas County and below, so Carroll County, things like that.
Do a lot of people like want mineral rights?
Oh, everybody wants them, 'cause there's
Okay.
money.
Yeah, cause I wondered about that, cause my seller wants to keep them.
It
So I'm
will,
like, is that gonna create less offers, you think?
Yes.
yes,
Okay.
I tried to explain this to a seller, I had a golf course listed down south and. Basically, this seller had gone through a bunch of agents and I teamed up with an agent that had more commercial experience and land experience and things like that. And we had this listed for sale and the seller was emphatic that she was keeping the mineral rights. And I explained to her that I am your 5th real estate agent and the value of this property is not what you think it is. Because you're keeping the mineral rights and she's like, well, it doesn't affect the value. I said, well, how much are you making on royalties per month? And she's like, well, it's enough to pay my property taxes and my house payment, do all this. Then you're making a few $1,000s a month that you're able to take care of this. That affects the value because those people are not going to be getting that with those mineral rights. And so she didn't disagree, we weren't able to sell, but I will tell you, it does affect the value. It affects the value drastically because the buyer, unless the buyer absolutely doesn't care. I mean, you know, if they're buying an acre lot in town, the chances are they probably don't really give a crap. But if they're buying 300 acres or 400 acres, they probably care.
And when they care is when they see that they're not included.
Yeah,
That's the truth of it. If
Yeah.
you don't know, oh, well, I want that. That's the response. And so I remember walking somebody 37 acres, they had 2 gas. Wells on their property. He didn't wanna sell them. I convinced him to sell them, which is hard to do. Because I said, that's the value of your property. As soon as you don't include it, it definitely will affect somebody.
people usually want mineral rights.
Appraisers can, or at least my sister does appraisals that can do like a hypothetical value or like extract. So
That's
you
good.
can actually see, so if you get into a situation like that again,
Okay,
you can feel like, or often I'll be like, we don't agree. Pay for the appraisal when it closes, I'll reimburse you for that.
yeah, no, that's a great point,
Mhm.
yeah.
And someone shared the tip, always good to check if gas available for buyer to receive free gas.
Yes, yeah, and be careful with that because sometimes
it is,
sometimes it's not free gas, even though there's a well in there, or
Or
sometimes
it's not
it's,
hooked up.
yeah, or sometimes it's. You can have free gas up to so many cubic feet
Exactly.
or whatever it is, you know, per month or something like that, so you have to be careful. It's not unlimited. Alright, so then lines 84 through 93, again, another section of our new purchase agreement, I really don't care for. You will see that it is automatically crossed out on line 89 where the seller is to pay for the cost of the title insurance. We've always in our market split that between the buyer and the seller. The attorney, for some reason, when she created this document, she has it in there both ways. Here it says the seller is gonna pay for it, later it says it's split between the buyer and seller. So I've gone ahead and crossed it out, I know it kind of looks foolish. Again, I have not updated the purchase agreement because it will get updated again in the next few months. Just know that it's crossed out intentionally. However, it is 100% negotiable. We split the title insurance in this area. In other areas, it is 100% paid for by the seller. In some areas, it's 100% paid for by the buyer. So
So ours will, just for clarity, ours is gonna be the way it has been, where it's split in the?
It is, it's already
Okay.
in here in the next section where the escrow section, and we will keep it that way.
Okay.
Yes, we will keep it that way. All right, proration, so this just says that the county is going, or the title company is gonna use the most recent tax bill that they have. They're gonna base the prorations off of that. The same thing is gonna be true for HOA dues or any kind of assessments or anything like that. Everything's gonna be prorated, and just remember the seller, when you're doing those net sheets, our taxes are 1 year in the rears, and the seller's gonna have to bring those current. And so that's one of the biggest things that sometimes they don't understand, because they have an escrow account, and they're like, well, no, I paid my taxes. No, you didn't. The money is there to pay them, but you have not actually paid them yet. They're 1 year in the rears. And then the line 108, escrow agent can withhold $250 is typically what I would put in there. If you have city water, sewer, and trash, and when I say city, I don't mean all municipalities, because for example, if you live in Jackson Township or Perry Township or Plain Township, you might have Aqua Ohio Water, which runs off your social security number, and it doesn't stay with the property. But if you are in Canton City, Massillon City, Akron City, those run with the property no matter what. They don't run off a person's social security number. So if a homeowner is 3 months, 4 months, 6 months behind on the water, sewer, and trash bill, because it runs with the land and it's the first lien against it, along with the property taxes, when your buyer takes it over, if the seller did not pay that final water, sewer, and trash bill or bring it current, that new buyer is responsible to pay it. It runs with the land. And so that you just want to make sure that you're aware that your title company is checking that or is not checking it, because it doesn't always happen.
When you do put that in there, also, I was foolish and didn't realize, I thought the title companies checked.
Hmm.
They don't, so that it's on your. What would be the seller to go back and provide them proof, which is kind of a pain in the butt for the sellers to remember to go back and do that, and they have to do that after closing. to get that-
It is,
to get
but for
that.
$250, it's worth it. I mean, if you, if, in my experience, and there are two ways to do it. Either the seller can get the final bill and send it to the title company. The title company will pay the final bill and send the seller the difference of the $250 or whatever amount you put in there.
Yeah.
But also, when I've done it as a seller, I just went ahead and paid it and provided proof that I paid it to the title company, and they sent me a check for the $250 back. But you're absolutely right. It's on the onus of the seller to figure that out. But that's, that's just another way as an agent that you're showing your value after the closing is, hey, I'm following up. Did you receive your final water, sewer, and trash bill or whatever? We want to make sure you get that money back. It's just another way to touch after they closed on a property. So it can be a great opportunity for you to reach out to them. And then the CAUV tax, most of the time we don't see a CAUV tax, but it does run with the land only if you apply for it each year, or however many times you have to apply for it. I think it's once a year. You have to have so much acreage and things like that. The reason that this box is important is because, for example, if you sold a property, let's say in Canal Fulton, that had 30 acres on it, and a farmer was farming 10 acres of it, or 13, 15 acres of it, whatever the case is. And the new buyer that you're working with says, hey, I'm gonna change all this to residential land because I wanna build a house on it and I don't want them to farm on it anymore. They're gonna lose that CAUV tax benefit, which reduces the taxes dramatically. And then also, not only does it reduce it, but because our taxes are 1 year in the rears, the county has the opportunity to go back and reevaluate that property at the new residential rate for, I think it's 2 or 3 years. So you gotta be real careful, because a buyer could end up with a $10,000 tax bill if they didn't expect, because you checked the box on here that the buyer's gonna pay for it. So understand what your buyer's doing with the land when it's a larger land residential purchase.
Make sure you tell the buyers too, they have to apply for it.
Yeah, because if they don't apply for it, they'll lose it.
Does not carry.
Yeah. Is it once a year? I think it is.
Yeah.
Once a year. So, yeah, again, another way to show your value. Add that to your sheets, to show your value. And then charges and escrow instructions. So this is where it says in here, if you see on line 115, where it says title examine 1/2 the cost of the insuring premium for the owner's fee policy. It is split between the buyer and seller. So again, it was just in there twice. The other thing to note here is in the section where it's the charges and escrow instructions are, if there are any other fees, whatever that would be, you can write that in on line 118. If a seller is paying something else or a buyer is paying something, that would go on line 125. Typically, We don't see that. I have seen some of our agents writing in the $2.95 additional commission fee in there. It's not necessary. You have that in the listing agreement. You have it on your buyer representation agreement. So it's really not necessary, but I have seen agents put that in there.
Let me ask you real quick, Rich, like sometimes you have places where you have to pay like an initial fee to be part of an HOA or something like
Yep.
that. Could that be something where they would write something like that if somebody wanted to?
Yeah,
Never
so.
got it, but I've seen where people have to apply.
Yeah, so I mean, Lake Cable would be a perfect example, the dredging fee of $5,000 that wasn't paid by the seller because they didn't want lake rights. Then they may not have paid it, but a buyer coming in may negotiate that in the purchase agreement that says, I want the seller to pay this $5,000 dredging because I'm only buying this property because I want lake rights. Well, then I might put that on line 118, or if I'm the buyer and say, I'm gonna pay for it myself, I need to make sure it's getting paid to the correct persons or entity, so I might put that on line 125 and make sure that it's paid, so I know I'm getting lake rights with my property,
Gotcha.
something like that,
They
yeah.
also have that one-time fee too, that.
Yes, they do have a one-time,
That's
it was
what I
a
was-
$1,000 orientation fee or something.
Even be
whatever it
too,
is.
yeah.
Yeah. And Lake Mohawk, I think, has orientation fee as well,
And Glenmore has some stuff.
Okay,
so,
yeah. so those are things that you could put in there.
Okay.
Lines 127 through 133, we haven't had to see in a while. It's contingent on the closing of a buyer's present property. And basically it just says that the buyer's present property is under contract. However, it is the closing on the new home that they want to purchase is contingent on the successful closing of the current property. And that's where that would be applicable, is on line 127 through 133. That's only if the property is actually under contract already. If it's not, you're gonna want to use a contingency or concurrency form and spell out all of the things and when the times start for inspections, earnest money, all that fun stuff. Home warranty, we've already gone over that same thing on the listing agreement, lines 134 through 138. If you're having a home warranty company, it's different in different places. We use America's Preferred Home Warranty. Some agents might still prefer 210. I know in Mansfield, Worcester area, they use a different one. Doesn't really matter, but that's where it would go. Megan's Law just puts the buyer on notice that we are not responsible for any sexual offenders, predators, notices, things like that. It's not on the seller. It's not on us unless they actually get a postcard. The seller gets a postcard. That means that the sexual offender, there's something about them that is close enough that they must disclose that then, but otherwise, they need to go on the county website of the sheriff and look up that information. I will tell you, it's scary. I don't care where you live, you go on there,
If you're near.
there are dots everywhere.
You've got it.
Damage or destruction to the property just says that, the seller is going to take care of the property up until the very day of closing. What's interesting about this is we actually did just have it where a Goodwill or a truck that was pulling a Goodwill trailer, the person was drunk, they ran into a house that we had listed and destroyed the garage and the brick and everything in the front of it. And the damage was definitely more than 10% of the home's value. I think it ended up costing over $70,000 to have this
Oh
all
my
fixed
gosh.
or close to it by the time it was all said and done. By the time the seller was paying 3-4 more months of property taxes, payments, the $40-some thousand in damage and all these things. So anyway, so I will say it does happen, but if it is in excess of 10%, the buyer has the right to say, yes, I still want to purchase the property. I'll take the insurance proceeds check. I'll fix everything myself. At that point, I think we need to get some attorneys involved, some hold harmlesses need to be put in there and things like that, because the estimates could be different. But basically, it just says that the buyer then has a right. Either I want the insurance money and I'm gonna move forward, or I'm not. And I would just tell you, in an instance that we just learned from, if there is damage, you need to cancel the purchase agreement altogether. We did not do that. We extended the purchase agreement. The buyer was not able to close until all the work was performed. But when we got to the nitty-gritty, it was a really disastrous transaction because the seller was not able to find, or the company wasn't able to find, the brick that was from the 1950s that matched the house. And the inside of the garage was the green tile brick that we have very prevalent in our area. You can't match that either. And the buyer, so the seller came up with the idea, hey, we're gonna put regular brick in the garage. We're gonna find a brick that matches on the outside. It won't match color, but the everything else will match the size and the texture. We're gonna paint the brick on the outside. I'm gonna paint it this white color because my siding is gray and I think that looks best. And the buyer goes, whoa, I'm the one buying the house. I want it painted this color. And by the way, I don't know that I'm comfortable with this contractor doing the work. I want a warranty. It got to be a disastrous thing. So I would just tell you, learn from our experience. If something happens to a property, it is better to cancel that sale altogether unless the buyer's accepting the proceeds check. Just don't do it. Alright, representation and disclaimers, this would be, you know, if the seller is acknowledging anything or paying for anything. Or the buyer is, you could put in there, if the real estate broker is paying for something, so. You know, if I'm paying for a home inspection or whatever, I'm gonna put this inducement in the purchase agreement, so everybody knows there is an inducement. Because I'm paying for something.
Mine should be longer than.
It should be, but hopefully you don't have to use it. I know we do, and that's wishful thinking. But it should be. And then condition of the property, again, it's as is. The buyer is purchasing the property as is with the exception of the defect, including the defects that were on the RPD. I think that's really important to point out to a buyer when you're actually going through this purchase agreement, because a lot of times it might say there was mold in the attic, or the basement flooded at this time, or whatever the case is, whatever the seller disclosed, and all of a sudden the buyer has a home inspection and the home inspector goes, oh yeah, I can see damage of previous water. Now the buyer's like, oh, I want this further inspected, or I'm not buying the house. No, you already agreed that you were buying it as is, and I disclosed to you on the property disclosure form, whatever it is that we're talking about here. You don't have that right to do it, you accepted it as is. So it's a great opportunity for you to really drive that home with your buyers at that point. And then either they did or did not receive the residential property disclosure form. One of the things that absolutely drives me crazy is that we had an agent, thankfully not at our company, but at a different company, they were telling us that our seller must fill out a property disclosure form on a mobile home. A mobile home is not considered real estate unless it's affixed to the ground. And so therefore, it is considered a car or a boat or any other piece of personal property that has a title. You're not gonna get an RPD always filled out on a mobile home or a modular home. The seller can elect to do it, that's great, and you can sell it, but they don't have to do it. And the other thing is too, is I have seen other brokerages, managers that will call me and say, you need to get your seller to fill out this property disclosure form. No, the seller is going to fill it out or not fill it out. We can't make them fill it out. We provide it to them, we hope they fill it out, but we can't tell them how to fill it out, and we're not mandating anything. If they choose not to do it, there are elections the buyer has, whether to close or not, and then it leaves the seller open to liability later, perhaps. That's between them and their legal counsel, not us. Okay, so if you really didn't get one, you need to mark you don't have one.
But the buyer can walk anytime on seller day.
Yep, the buyer can walk up to the very day of closing, is my understanding, without any repercussions from the seller whatsoever. Yep. And then this was, I think it's only happened in my career in one time, but there was a gas line leak in a neighborhood. It happened to be in the house that we had listed for sale, in the front yard, and the front yard had to be dug up. I don't know if that's why this was put in here, because this dates way back to my early days in the 2000s as a licensee, but it just says that the seller is going to pay for any leaks of the gas line between the street and the property.
Weird, I didn't know what to do with it.
Yeah, and it really, it's just, the box there on line 174 is how many days after receipt the buyer has to decide who's gonna pay for it, right? So, I mean, I typically put 5 days in there because you need time to get repair estimates taken care of and figure out then who's gonna pay for it. At the end of the day, if there's a gas line leak in the front yard or a side yard, anywhere in the yard, the seller's not selling that house until it's taken care of. I mean, ultimately, that's what it would come down to. Unless the buyer says, I'm willing to take it on, and that's fine, they could be, maybe they're getting a good deal, but you can put 5 days in there, 3 days, something like that.
How would this be figured out when they turn it off and turn it back on? Like, that's what, I don't.
Yeah, so, well, whether it's turned on or not, so
Or
in the
just
case that
happens or
I
happens.
know of, a particular neighborhood was using more gas than Dominion thought that they typically should for that time of year. They knew that there was a leak somewhere in the neighborhood, but they couldn't pinpoint exactly where it was. So they started going out and using probes that must be able to smell gas or whatever, and they were probing different places near the gas lines to figure out where the leak was. It just so happened that it happened to be in the front yard of the listing that we had. And now who's gonna pay for that? Because the line between where they shut it off at the street and the house is the seller's the owner's responsibility. That just happened to be a fluke thing, but it does happen, and also, it's in there because as we start to see more foreclosures happen. And the gas does get turned off, when they turn it back on, they do a test on that line. If that line shows a leak somewhere, somebody's gonna have to pay for it to get fixed before they turn it back on. And
It's funny
so,
that you say that, cause it just triggered, I remember, there is a gas leak in my front yard, like, they came out and found. And they kept marking it, saying they're gonna repair it, they never come to us, and I don't think they've ever repaired it,
Well-
they said it's such a slow leak, but it's right in my front yard.
And it could be on their side of the line, so maybe
Okay.
that's why they haven't
It's
fixed it yet, but
close to right.
it can happen, I mean, I wouldn't want a natural gas leak in my front
I
yard.
still have one, so.
Don't let it match,
Yeah.
but those are the.
Yeah, well, that's crazy, but they were just out there doing that, they just replaced the con, like,
That's why they
that
charge.
block right in front of it.
They
Yeah.
have that fee that you can pay to fix between
Yeah.
where they turn it on and off in your house. It's
Yeah.
like $10 a month.
Mhm.
Yep, same thing for furnaces and all that fun stuff. It's kind of like an additional warranty that you can get.
Yeah.
Yep. And then inspection, so the whole next section is really about the inspections that the buyer is allowed to do. Our purchase agreement in Northeast Ohio is a little bit different. We check the boxes for all the inspections that they're gonna do, but if you get one from Columbus for some reason, the buyer is allowed to do any inspection known to man, and they don't have to get your permission to do it. They're just allowed to do all of them. So you have to be careful reading these purchase agreements, what can and can't be done.
I wish that was not negotiated. I wish people could get whatever inspections they wanted because so many people who did it during our,
Yeah.
you know, I just feel bad that somebody.
But as a seller, I think purchase agreements are meant to typically side with the buyer, but if I'm a seller, I'd rather know what inspections you're doing on my
Well, no,
property.
that's that, but I'm saying I wish they couldn't say, I don't wanna accept your offer because you are doing inspections.
Oh.
That's what I'm saying.
Gotcha.
I think that the right to inspections, I'd love to see that protected for buyers.
Well, they have the right, it just makes a
They
difference
might
when
not
their
take the
offer's
offer.
gonna get.
Right, that's
Get
what I'm trying to say. I wish they could at least minimum
Yeah.
that.
But basically it just says, you know, that the buyer is accepting the property, basically, and it's again, as is, you know, and they personally inspected it, they're gonna have an inspection done on the property. And that they have to choose a licensed home inspector, it can't just be Uncle Bob, it has to be a licensed home inspector.
Yep.
And then they have to check, 204 through 214, yes or no, I'm having the inspection, I'm not having the inspection. Typically, we see, for general home inspection, I usually only see between 7 to 10 days. I really haven't seen 14 lately, because buyers are trying to make their offers better and the less time that you have. But you have to really make sure that you understand that a home inspector can get in there within 7 to 10 days, because if they can't, you better extend this, because once you go past that time, the buyer is not just automatically allowed to have another inspection because you went outside the time that was negotiated as part of this. The water potability, typically, you know, we have a well, we're gonna do that. If you have a VA buyer, you can mandatorily check the water potability if it's a well, because guaranteed they're gonna want 5 inspections, nitrates, nitrites, lead, bacteria, and something else, but anyway, they're gonna check all of those things. Well water flow rate, and then whether there's radon gas, mold, pest, wood destroying insect inspection, lead-based paint, and any other. The other could be an HVAC inspection, could be a roof inspection, a pool inspection, could be anything like that. One of the things that I will tell you is on line 215, this is where the buyer is initialing to say, anything I've checked no to, I don't have the right to do. I do not have the right to do those
It
inspections.
used to be above that, right?
It was above.
And the lead-based paint, that wasn't where that was before, right?
No, the there is a lead-based, there is a pest inspection later in it too.
Okay,
Yeah, there's, like I said, there's a few things in there that just don't flow as well as I'd like.
Yeah.
We need to get changed. But we have
That's
those.
a little
notes.
back where all the other ones are. 'cause
Yeah.
it gets-
Yeah, it gets missed, agreed.
Yeah.
And then basically within 3 days after the completion of the inspection, that the buyer is going to provide an ROC, right? So Cutler is the only company I know of that doesn't do ROCs around here. Everybody else, it's within 3 to 5 days, you have to have an ROC. But the timelines in this are very important, because you only have 3 days from the date of the last inspection. And we went ahead and defined what that was on line 224, because I had a lot of other companies that would say, well, the home inspector was out on Tuesday, that's when your date started. No, we didn't get the inspection report until Thursday. Or we didn't get the inspection report from the county until next Tuesday, or whatever the case would be. So we put the completion is defined as the date the buyer receives the written report from the inspector, county, municipality, or wherever it's located, so. Right, and then within 5 days from that, you have to have a fully signed ROC. So the question I get a lot of times is, you know, my buyer wrote an offer, we got to the ROC, the buyer said, I want the seller to have an HVAC inspection and fix the roof. And the seller says, nope, I'm not gonna do that. Well, that doesn't give the seller the right to say our contract is terminated. The buyer has the right to then say, okay, I asked you, you didn't wanna do it, I'll buy the house as is. But basically, if you get to a point where 5 days have passed and you don't have a fully executed ROC that's releasing everything or dealing with all of the items. The buyer or seller could void this contract at any point in time, and it has happened.
What about when you have to negotiate, repairs, you know, conditions on the ROC and like the. Sellers wanna get estimates and stuff and it drags on and it often does.
Yeah.
Like,
So in that case, then what I would do is if you, let's say there's a pool inspection or an HVAC inspection, they can't get out for a week. Let's just hypothetically say, I would extend the inspection period. I would do an addendum that says the inspection period is extended by 10 days. Or put a date on there or whatever, because you need to leave that negotiation open.
Yeah.
So the only other thing that I've done is on my ROC, I will be very specific. I will say. Seller to have qualified HVAC inspection completed before closing. Any repairs or replacement recommended by HVAC company are to be completed at the seller's expense. I feel like that's pretty good because. It wasn't an and or, it's a, if they recommend replacement, you're replacing it. I didn't put a cost on it. If they're recommending that you add things to the furnace or change it, whatever, you have to do it
you're putting that under ROC or under.
on the ROC. Because sometimes sellers or buyers don't wanna wait for a repairs, the ROC for estimates to get done, or a seller says, listen, I'm willing to do it. I didn't know that the heat exchanger on my furnace was cracked. Well, I'm not worried about getting estimates on it. I'm either gonna give you a solid amount or I'm gonna replace it. But it doesn't bind the seller to say, oh, it's a $5,000 repair or it's only a $3,000 repair. I'm just telling you, you pick the person, if they're qualified, you're putting in a new furnace. If
I
that's,
always say that I wanna see proof of the receipt that it's a licensed person won't work.
yep, that's fine too.
Yeah,
You just have to be careful how you write ROCs.
Yeah.
Extending the inspection period is the safest thing to do if you don't know what the cost is or who's gonna pay for it. Extend it, then you have a full picture and you can negotiate. By the way, we only do one ROC. I have seen where agents will do an ROC for a pest inspection, an ROC for a lead or a water inspection, another one for a home inspection. Put yourself in the seller's situation. You don't want all of those, and if you're asking for something every time an inspection is done, I'm gonna get real irritated as the seller, and you're just gonna irritate me to the point I'm gonna say, I'm not doing anything else.
Yeah.
Present me with all the facts up front so I know what I'm gonna spend, otherwise, you're nickel and diming me to death and I'm gonna get kind of irritated. So,
Extending the inspection period, Rich, would you recommend we do that on the purchase agreement or as an addendum?
I would do it as an addendum. Yeah, once the purchase agreement is negotiated, we really shouldn't be changing anything on it. It should be exactly the way it was. That's what addendums are for.
Yeah.
So, yeah. All right, and then let's see here. Lines 239 and continues on, just says, you are going to agree in writing to extend the dates for inspections, repairs, or whatever. And that is true. You don't want to do anything verbally, right? So you have to make sure that it's in writing. And then this is where we were talking about, like I said, we'll probably take this part out, lines 244 through 252, where it just says about the wood destroying insect. It says who's going to pay for it again, which we kind of already have that up here, where it says on line 212, pest inspection, who's gonna pay for it, so it's kind of redundant. But then also it does say in here, that the agreement may be voided by the party paying for the repair and treatment if the cost exceeds $500, which can be a benefit to a seller if they choose to do that, or a buyer, because a buyer may say, listen, I was willing to pay for $500 in repairs, but the fact that it's $3,000 because termites have eaten the whatever, the beam of the house, I'm out. Yeah, or the seller could say the same thing, so. Yeah, might have a little bit harder time paying or selling the house. And then lead-based paint, same thing, that the buyer has or has not received a copy of the EPA pamphlet entitled Protect Your Home and Lead. I would just tell you, if it's not a part of your process to send that with your offer, you need to be sending that all the time with your offer, because if you are ever audited or there is a division complaint, or God forbid that there would be a lead-based paint, a child would eat lead-based paint, and you didn't provide that pamphlet, but you checked on here that it was, even though the buyer acknowledged it, if you don't have a way that you can show through dot loop or some other way that you provided it, you're probably gonna be found guilty of not providing it and getting a buyer to agree to something that they didn't understand. So make sure you're providing that on any house that was built prior to 1979. Any additional terms, anything you can think of, I know there's only 2 lines there, but basically any additional terms, that you can think of that you would need to put in there. Sometimes it could be, the offer is contingent upon OFA approval or something like that. Canton City, housing finance, maybe they're giving the down payment, it's contingent upon that, or, you need their final approval or sign off, so those could be things. Authorization, this is great, the escrow agent's able to give us a copy of the settlement statement, whether we represent the buyer or the seller, that way we can see the true picture and look over everything for our clients. And then confidentiality, this is big because a lot of times a buyer thinks that when you write an offer on a property and you give that offer to the listing agent, that the listing agent can't, or the seller can't share that offer with anybody else, and that's not true. They can share it with anybody they want. They can shop that offer. So if Nicole gives me an offer and I represent the seller, and Mark as my seller says, hey, Rich, I want you to shop that offer if you can get a higher price, I could put it on Facebook and say, hey, I've got a house at 1234 Main Street. My seller has an offer for $140,000. Anybody want to beat that? Absolutely allowed to do that.
Wow.
I'm not giving away names or anything, but as the homeowner, they can absolutely instruct you to share that offer and shop that offer if they want to. So just understand that once we give that offer, all bets are off. The seller has no duty to the buyer or the agent of confidentiality.
Under that, just looking, so the last 3 words, its terms. Is that
And may
intentional?
disclose its terms. Nope, that's another one. Yep, so. Yep, that would be another one. And then .loop, just a cloud-based system, of course, just giving permission that, we understand that that's where it's at. Dower interest, this is one that we had the other day. We actually, you need to make sure that a seller that is married, whether they're married, if they're legally married in this country, then they should be signing a listing agreement, they should be signing a purchase agreement. It can happen, and we've seen it happen to where seller doesn't tell us that they're married. One of the sellers signed the purchase agreement, the other one doesn't. We get all the way to closing, the title company says, oh, you're married, even though you filled out not married on the form on the pre-closing disclosure. And now we can't file the title because your other spouse hasn't signed off dower. You will be held up by that, as we're down to 2 states, Ohio and one other state. Arkansas, there you go, it was 3 that have dower, and that's it.
What about if the property's held within that LLC?
So an LLC would be different, that's considered a whole different entity, so whoever is on the LLC documents, that's who's able to sign. Yep. And in that instance too, I would just tell you, that you bring up a great question. Anytime you as an agent own an LLC, there is still no reason that you can't disclose that you're either buying or selling something. I understand an LLC is a separate entity, but if you are a member of that LLC, you should be disclosing that you are a licensee in the state of Ohio, whether you're the seller or the buyer. Yep, and then any addendums that would happen to go with the purchase agreement, I will tell you, when you check these, lenders do pay attention to them. And so therefore, if you have a lead-based paint disclosure, they probably want that. If there's an affiliated business disclosure, they probably want that. So if you check it, you should be able to provide it to the lender. And then just as it is a binding agreement, they can talk to legal counsel, either party can, and then they sign everything and fill out the listing agent, buyer's agent information. Was there a question, Nicole? I thought I saw a flash.
Sheila was asking dower interest relative to being, if it's held in a trust,
Oh, perfect.
and so the same rule would apply as LLC.
Yep, same rules apply. Yeah, absolutely. So, all right, any other questions? We've kept you at 1 hour and 34 minutes. But any questions?
I just sent a text to you so that I wouldn't forget. Someone asked if you could add the zip code to the purchase agreement line 2. A line for the zip code.
Yeah, that's interesting. Oh, on line 2. So it should put the full address in there. Yeah, it should put the full address. If it's filled out correctly, it should put the full address, including the zip code. It shouldn't have to be separate. I will look at that though, because if I filled that out incorrectly for the address, I'll make sure it says full address, not just like the numeric code and the street. I'll make sure it puts everything in there. Like Tracy is able to mark up the document here. She's crossing it out. So any other questions?
Oh.
Rich, forgive me if you covered this before I walked in, buyer broker comp.
We did not do that form. I can.
I wasn't sure.
Form or off of here,
What's that?
the form or what was on here?
Should it be included in the boxes that are checked for additional documents that are included as part of this offer?
Yeah, so our attorney has not allowed us to put it in this document. I can't tell you that that will be the case later. Let
Okay,
me scroll to the addendum, so where it says other on 293, I have seen agents check that and put buyer broker representation or buyer broker compensation.
yeah,
She has told us that she does not want compensation to be a part of the purchase agreement unless the buyer is telling you, I want you to ask the seller to pay it.
okay,
Then don't put it on the purchase agreement, and that's why we haven't checked that box and it's not pre-typed. I will tell you, I think one of our sister companies is going to do that because they feel like it's necessary. I don't know that it's necessary based on our legal counsel, she's claiming no,
okay,
but
that's where we're at right
yeah,
now.
that's where we're at for now.
A lot of differences of opinion on it.
A lot of differences
Yeah.
of opinion, yeah. Yeah, like I said, we just came from a broker manager meeting last week and the presenter basically said, listen, everything soon is gonna be on the purchase agreement. If it's included, it better be on the purchase agreement, and that's just the way it goes. So we'll, more changes coming, I'm sure.
By next summer.
Okay, well, thanks for your time, guys. Thanks for everybody on Zoom. I appreciate you very much. For those of you attending in class, I appreciate you coming in too. It's nice not to be here standing alone looking at the computer screen, so thanks.
Thanks, Rich.